So let me just get straight. So if the transaction, like you signed on the papers and then someone passed away before closing.
Like, let's say the day before, as an example. Bad luck.
Yeah.
This happened to one of my clients.
Well, it actually happened to me.
Did it really?
Yeah. It was back in 2018.
Yes.
But let me see what you have to say about that, because I had no idea what that happened. Because I recall this family that I had their condo up for sale. It was a pretty large condo, and I was asking, where you guys are going. They said, we're gonna just move to our daughter. So it was just a straightforward sale. And I recall I called them the day of the transaction. No one picked up. Next day, and I called for a week. Nothing happened. I was going away, and then I got a call 2 weeks later from the wife saying that literally the night before the husband passed away, before the closing, the husband passed away. Hi everyone, and welcome to another episode of Real Talk. Today we're gonna have our guest Sarita Samaroo from SST Law Professionals. Sarita, thanks for coming.
Thank you for having me, Nima.
So, as every episode in Real Talk, we talk about what's important in real estate or something surrounding real estate. So today, what we're gonna talk about is one of the, I would say, most important issues hovering around real estate, which is estate sales, which could be complex, could be confusing, and a lot of people have a lot of questions, especially if you're dealing on the sell side or even if you're on the purchase side. There's a lot of confusion. So today we're gonna dive deep into it and just go over the process. So let's start with, what is an estate sale?
Sure. So an estate sale is when a party has passed away and the property is frozen, essentially. So there isn't the requisite authority to actually sell the property until we receive what we call an estate certificate from the courts. And you can die something called with a will, testate, or intestate without a will. So in order to get that requisite authority, we need that estate certificate from the courthouse. And without that, you don't have the authority, that party, whether it be a spouse or a child, in order to sell the property, unless, depending on how you took title at the time that you had ownership with another party. But in most cases in Ontario, it's last to die. There is, for example, a spouse that has passed, and now it's the remaining spouse, and then now the property is going to the children. So therefore, we have to ensure that the estate is administered properly if the children weren't previously added to the title, so as to pass it on automatically to the children.
Okay, so just to get straight, so if there were other people on title, it would automatically get transferred to them.
Possibly, dependent on how they took title.
Exactly.
So if it's joint tenancy, then there's something called rights of survivorship. And whoever that may be, it doesn't even have to be a child or a spouse. It can be a friend. Whoever is actually on title as a joint tenant, it passes with rights of survivorship. And you avoid estate tax, which was formerly known as probate.
Okay.
And estate administration tax is payable on the 0.5% on the first 50,000 and 1.5% on the remaining value.
Okay, so let's go back to it. So first, if there's anyone on title, it will pass on to them. But if it passes, there's going to be a tax that they have to pay in order to get ownership?
Not as joint tenants, but
Okay.
if they're on title as what we call tenants in common, then tenants in common is based on whatever percentage share, and that percentage share is taxable in the hands of the estate. So if it was a 50-50 ownership, by way of example, that 50% ownership of the deceased is now taxable in two ways: to the estate courthouse, which would be the estate administration tax, formerly known as probate, and then as well there's something called a terminal return, which is payable to the CRA. And that's separate. That's something that an accountant will deal with. But from our perspective as lawyers, we're handling the estate side. We're calculating the estate administration tax.
Okay.
Once that is paid and administered, and it's based on the overall value of the assets, where there was not either A, a designated beneficiary on the assets, or B, if there was an asset in which there was no one entitled to it, such as a sole checking account or a property in which there was only one singular owner, then it would fall into the hands of what we call estate administration or probate.
Okay, so if that, let's just talk about the bank account, had a beneficiary, it would automatically go to them without a tax?
If there's a joint bank account, or what a lot of people don't realize is that there's a designation you can put on a bank account with a family member or a spouse or whatever the case may be. If you want to maintain a sole checking account, it's called rights of survivorship designation. And so if you don't want to have a joint account with your spouse, or you don't want to have a joint account with a partner, you can put a rights of survivorship designation on the bank account, and then it will pass. But
Without a tax.
Without the tax, yeah. If there's a designated beneficiary, by way of example, if there's registered investments and there's a designated beneficiary, it will still be frozen at the time of death. However, there won't be any estate tax on that, estate administration tax.
So you mentioned something about how the tax is calculated. How is that calculated? And is it the same between, let's say, land and a bank account?
Yes, it's calculated in the same manner. So it's 0.5% on the first 50,000 and 1.5% on the remaining value of the overall assets, whether it be real estate, whether it be personal property. However, if the overall value is under 50,000, a new rule came out on January 1st, 2022, in which there is no estate tax payable on an estate valued under 50,000.
Oh, wow.
Okay? It's called a small estate application. It's a faster process through the courts as well. However, how do you fall under that category? If you're careful and prudent and you do proper estate planning, you'll ensure that you have designated beneficiaries on all of your assets, and you have the rights of survivorship designation on all of your bank accounts, or have a joint bank account, and that's proper planning. If you don't, then it falls to estate, and that then increases the value of the overall assets. So it's based on the value where there is not a designated beneficiary, or if someone is not added to title with you, then that increases the value of the assets. So if you're a careful planner and you have everything held jointly, let's say with a spouse, or you're a careful planner before your death or before any capacity issues, you add your children to title, you think about it or consider it, depending on what will cost more, whether they have secondary properties, they may have to pay capital gains tax. You can consider what will work out to be less, the estate administration tax or the capital gains, whatever the case may be. But it's something you have to sit down and have proper advice on. So that way, and then in that, you need someone to help you with tax planning. You need an estate lawyer to help you with that, and a combined real estate lawyer preferably. So because we have an understanding of both. And then as well, you happen to have your financial advisor involved. So there's three crucial parties that are involved. And that is important for you as a realtor as well, because before it goes to market, you have a proper understanding of how the planning process works, how the estate process works, and before you list the property for sale.
Got it. So if someone wants to do the proper planning, it would involve a tax accountant, a tax lawyer, and probably a real estate lawyer to plan this properly.
Yeah, an estates lawyer and real estate lawyer. We have some tax knowledge as well, so it's important to hire us. Yes.
Okay, so let's just talk about that 1.5% that's getting taxed on. So let's just say value of a property is $1 million at the time of death. So $15,000 is going to go to the
courthouse. So to the Ministry of Finance, to the province of Ontario.
Any other taxes?
There will be the CRA. Eventually you have to file your last income tax return. It's called a terminal return, and that's filed with the CRA. That's why you need an accountant. And before the funds can be released to the beneficiary, there has to be a CRA clearance certificate. And a lot of people and beneficiaries, executors, now known as estate trustees in Ontario, was formerly known as Executor, they have to ensure that that is completed before they start distributing funds. On one file that I worked on recently, there was a client who went to a different lawyer, and the advice on the lawyer was to just distribute upon receiving the estate certificate, which was improper advice, in that there was tax considerations to be made, capital gains tax considerations, where it should have been referred then to an accountant to calculate. And then the estate had to go back and pay back those capital gains. So it's something to consider, is that you want to ensure that you get the proper advice, you understand what the consequences are when someone passes. And so it is quite a duty, and it can be complex for an estate trustee, also known as executor, but you do need the right advice.
Perfect. So now let's talk about two situations, if there is a will or if there is not. So let's talk about what is a will.
So a will essentially is your wishes before you pass on, before your death, of who you would like your bequests, also known as the gifts in your will, to go to. So it's quite simple. Typically in a usual set of circumstances where there are spouses, it would pass to the spouse, because under Succession Law Reform Act, spouse has first rights over the estate. Then it goes after that, typically to children and then grandchildren. And then we address something in our wills called the common disaster scenario, so that it's addressed that in the event the whole family were to perish, who would you leave your assets to? And so we take in that consideration into effect. So it's a very thorough will. Then you have your executors, formerly known as executors, now known as estate trustees, and you would name who would have the management of those assets upon your death. So typically spouses name one another. Then you name, let's say, an adult child as an example. It has to be someone over 18, someone that you trust, that's fiscally responsible. And then a third party could be a friend, family member. There's also the option that a lot of people don't realize, something called a professional trustee. So you can nominate the banks or professional wealth company, wealth management company, to manage that. So your trustee, also known as a state trustee, executor, can take a management fee out, and it's typically 2/5 of the assets. However, that being said, one-time fee, overall value, 2.5%, okay, of, let's say, $1 million as an example, is what they can take. So if they choose to take that fee, if you hire a professional trustee, they take 3%. 3% is the typical fee. As an example, Royal Bank, TD Bank. So a professional trustee, if you don't have anyone, some people do not have anyone to nominate in their will. And then we put in the special clauses so as to be in line and with the requirements of that particular banking institution. So that's an option. So that's when you have a will. When you die without a will, that's dying what we call intestate. And your spouse actually doesn't have full entitlement to all the assets. They have the entitlement to the first $200,000, and then the rest is to be distributed amongst, let's say you have children. So it's something to keep in mind that there is a right of the spouse to have an automatic claim to the estate if you're legally married. However, that being said, when you die intestate, it's not an automatic right that the spouse applies as executor. An adult child can apply. There can be other parties that can apply. So how to avoid that confusion is to draft a will and get it properly drafted by a lawyer, because we can ensure that we have all of the requisite requirements that need to be in there when drafting a will, such as 2 independent witnesses, affidavits of execution, which means that the witnesses were present and that someone could swear and attest that they were present, being ourselves as lawyers or commissioners for taking oaths. And we can ensure that everything is set up correctly so that the will isn't rejected by the courts or there aren't issues where it has to go before a judge. So the main differences is that a will, when it's administered, goes before a court clerk at the courthouse. And when you die intestate, it goes before a judge. And as an example, City of Toronto is quite challenging right now. There's only about 4 estates judges that serve our population, which is close to 4 million people. So it's 1-to-1 ratio currently. So if you can think about that, if you can avoid that line and you have a proper will and actually have your will administered through the court clerk versus a judge and have it reviewed.
So how long does it take, if right now, as of today, if someone wants to go through the clerk or the judge? What's the time frame we're looking at?
So the time frame for with a will dying testate is typically 6 to 8 months. Okay, there's a minimum period in which the court waits approximately 2 to 3 months, so that if any children that maybe you were unaware of or any parties want to make a claim to the estate and have a will challenge or protest the will, right, can come forward. And so there's that minimum period for a regular estate, not necessarily a small estate application. A small estate application, you can't file it for 30 days after signing. Yeah. And it's usually a 6-week process. That's the under 50,000 application I was telling you about previously. But for a regular court application, 6 to 8 months. And then if you die intestate, it can take up to 2 years.
Oh, wow.
Without a will.
Wow.
So it is quite a lengthy process. And that in turn can affect something like your real estate process. If you as a realtor are looking to list a property for sale, you have to wait typically till that probate comes through. The only way around it is if you have a will, whether you die testate with a will or without a will, is we can give a letter of urgency to the courts. And when we give a letter of urgency to the courts, that can help expedite the process if there is some sense of urgency for closing.
So that's to expedite the selling procedure.
Correct.
So let's talk about if someone passes away. What happens if they have a mortgage on the property? Like, would that property go into the power of sale, or what's going to happen?
So it's the executor's duty or estate trustee's duty to notify the bank and it's the bank's obligation to freeze those accounts. Everything is to be frozen upon death. And the reason for that is to ensure that these ongoing payments don't have to be made. It is the estate's trustee's responsibility, though, that if there are funds available, to ensure that any debts are paid first. Okay, and if there are funds available through life insurance proceeds, because life insurance is available immediately. So if there is life insurance available, there is no freeze on those life insurance.
So you get the funds
proceeds.
and then you pay out all the debt
Correct.
right away.
Right, and that is the benefit to getting life insurance because it falls outside of the estate.
So whose responsibility is it to pay the debt?
The executor or
Okay.
estate trustee. Yes, so it's their responsibility to ensure that everything is paid before distribution, before and whatever's available. Sometimes there is a shortfall. Sometimes there are issues where the banks can write it off if requested, because sometimes there aren't always funds available and there might be a loss to the banks.
Got it.
That being said, the banks will iron out and look at the priority of debt. So
Yeah.
secured versus unsecured. Secured will always take priority.
Got it. So let's assume they freeze the mortgage, so meaning there's no more interest accruing from that point on. So if let's say it takes 2 years to get the probate, the state is not responsible for the accrued interest on top of interest or anything else.
No, they very well might be, because again, that's something. If there's funds available, and if there's funds available, the bank will likely have that accumulated and collected.
Oh, wow.
Yeah. That being said, but however, it should be frozen as of the date of death.
Okay.
That being said, as long as the bank was notified immediately, but typically the rule is in your mortgage provisions, it should say something to the effect that within 6 months of the date of death, you should be notifying the bank.
Okay.
And sometimes there's a lag with executors, estate trustees in doing so.
Okay. So that's 6 months. Then they're collecting, and then from that point on, whenever they get notified, they pause it.
That's right.
That's good to know. Okay. So let's now talk about selling of a estate. So let's say as an agent, whenever we're selling estate sales, I notice, just the name on top, who the seller is different. And then we have certain clauses. So let's talk about that. Let's start with the name. So I've seen sometimes power of attorney and sometimes I've seen state of. What's the difference?
So power of attorney is while that party is still alive, but they've lost capacity to manage their affairs. So this is probably the family preemptively looking to sell the property so it doesn't fall to the estate.
Yeah.
And they're selling by way of power of attorney. So funds are available to that person, that party, for their care. Like as an example, they're in a nursing home.
Yeah.
So that's when it's prudent. And I actually recommend that to my clients. If the power of attorney is able to try to sell the property before death, and you know that it's impending, and that power of attorney has been put in place, but there's something to be very aware of that the Director of Land Titles came out with in real estate a few years ago. So what happens is, let's just say, Nima, you have a client that signs a power of attorney, sells by way of power of attorney with you, and you've listed it as POA. Then the property, let's say the closing was supposed to happen the next day, they die the night before. They've signed all the documents, though, at the lawyer's office. What happens? Goes to the estate.
Wow.
Okay? If we didn't transact and register that deed, okay, and that sale did not occur by way of power of attorney, guess what? The sale stops, and now the estate has to be administered. Why? Because the Director of Land Titles came out with a bulletin stating that is called a zombie deed.
So let me just get straight. So if the transaction, like you signed on the papers and then someone passed away before closing,
like let's say the day before, as an example, bad luck.
Yeah.
This happened to one of my clients.
Well, it actually happened to me.
Did it really?
Yeah. It was back in 2018.
Yes.
But let me see what you have to say about that, because I had no idea what that happened. Because I recall this family that I had their condo up for sale. It was a pretty large condo, and I was asking, where you guys are going. They said, we're gonna just move to our daughter. So it was just a straightforward sale. And I recall I called them the day of the transaction. No one picked up. Next day, and I called for a week. Nothing happened. I was going away, and then I got a call 2 weeks later from the wife saying that literally the night before the husband passed before the closing, the husband passed away.
Oh, bad luck.
But the funny thing was the transaction closed. So I don't know what had happened there.
It could have been the bulletin hadn't come out yet,
Yeah.
because in and around in that timing, it only came out a few years ago.
Okay.
So, but there is a bulletin. Actually, it might have come out in and around 2018.
Right.
But there was a bulletin that was released where the new director of land titles, who had transitioned around that time, had said, no, that is no longer permitted.
Okay.
So even if you signed with your lawyer the night before, the power of attorney signed on behalf of that
Yeah.
party, and they passed away the night before, and that deed was not registered that same day while they were alive,
Wow.
it becomes a zombie deed.
Okay.
Very scary. So that happened to a client of mine. Unfortunately, the daughter, who was the power of attorney, never got around to actually signing the documentation with me. Mother died the next day. So we had to file the estate. And we had to get wait
Yeah.
for the estate
So
certificate.
that whole sale fell apart.
That sale was delayed.
Oh, delayed.
It was
So
delayed.
that's my next question. So let's just say in the situation you had. So the next day the sale doesn't happen. So you have to wait to go through the probate process.
Correct. That's right. And luckily, the mother had actually drafted her will with me. So the estate process was pretty smooth, pretty straightforward. And we were able to get it sold in the end. And it worked out in her favor because the market had increased at that
Yeah.
time. So it worked out. But that being said, these occurrences can happen. So it's prudent that if you have family members that are seeing aging parents and aging family members, to maybe get that in place, get that done. So that way the funds are available, and then they're put into almost a joint account, so that account now is not frozen in the name of that party.
Yeah.
And that's accessible for that power of attorney for the care and management. But the power of attorney has a fiduciary duty to that person. While they're still alive, they have to ensure that they take care of their care and management, and they're not absconding with the money, using the money for their own purposes.
Yeah.
So you have to really choose someone you trust.
Yeah.
And then when it goes to probate, let's say it's an estate sale. The estate sale, the difference is that when you draft the offer, for the power of attorney, you see by her POA.
Yeah.
And you'll put in the name of the party that actually owns the property, but then you'll put in brackets by her or by his power of attorney, and put the name so that it's clear to all those reading it, including the lawyers, that we have a clear understanding of who those parties are. If it is by way of the estate, then you're going to actually put in the name of the deceased, and then by his or her estate trustee, and then put colon, and then the name of the party that is applying for probate. Already may have the estate certificate and ready to sell. And it's prudent to actually have the estate certificate already in hand for that sale. However, there are times where it's about to be processed and you still need to list it because it's imminent, because you're getting notices from the bank or whatever the case may be, that the mortgage is to be paid out. So if that is the case, then you may want to list it, and then you put in special clauses that allows.
So who do you list it underneath? Like, what's the name?
For the deceased, they put the deceased name.
Yeah.
And then in brackets, the estate trustee's name.
Okay.
Okay. By his or her estate trustee, colon, and then the name of the executor or the person applying to be executor.
Got it. And okay, so that goes on the name. And then what about some of the clauses? But before we get into the clauses, everyone has noticed for estate sales, everything is being sold in an as-is, various condition.
Correct.
So if you can explain, first of all, why is that? And what's the clause for it?
So why we recommend that as lawyers to put that into the section 6 of the agreement in the chattels section, as is where is condition, and as well as putting into Schedule A. We highly recommend that in our office because we suggest to all of our sellers that in the event you're an executor or estate trustee, you don't know if something is broken down. You really don't. You're not there every day checking up on the property. If you are, that's wonderful. If you happen to live there, that's great. But if you don't have the time, and you as a realtor don't have the time to go in there every day and check on the appliances, we can't guarantee the state of a fridge, stove, washer, dryer in terms of the chattels. You cannot guarantee, right? If the furnace is in working order. I mean, you should make sure the furnace is obviously in working order, but you can't guarantee. You can't guarantee. You're not there to maintain. And not to say that as an executor or estate trustee, you're exempt from not maintaining a home. Of course, you have to check up on it for insurance purposes and make sure. But what about the bad luck? The burner goes out. Or what about the bad
flood.
luck? Right, exactly, or the recent flooding we
Yeah.
had. So that being said, my recommendation all the time to my clients in these circumstances is to ensure you insist they're purchasing on an as is where is basis. Typically with estate sales, they're getting a deal because the estate trustees are in a hurry to sell the property. So the buyer should accept that. And they can get their own home inspection to double check everything's in working order. Really, the responsibility lies
With the buyer.
with the buyer.
Yeah.
And they're buying it, understanding that. And so as is where is, well, while it may not always be enforceable in the court's eyes sometimes, we still recommend it so that the buyer knows that they're buying something where it's not a maintained property year round by the existing seller.
Got it. So that's one of the clauses. What are the other clauses to be inserted?
Yes. So our recommendation to all of our clients is that you put in, and to the realtors, is to put in a 120-day window, which is your typical OREA clause. And you put in a window in which allows for an extension. So if the probate hasn't been received yet, then it allows for a further extension, but not for a period of more than 120 days. And then the buyer can get back their deposit in full, returned without deduction or interest, and we highly recommend that. So that's important to know, because that you shouldn't keep the buyer on the hook if they want to move on. And typically in a lot of these cases, you get investors with these type of properties.
Yeah.
They're going to do a reno job, or maybe a buyer that's getting a great deal and they're going to renovate it in any event, because the state of these properties are generally not the best always.
That's interesting. That's usually the case. So, so these are I would say, two of the most important clauses we gotta put into any estate sale. So one of them being the probate clause, like the extension till we get the probate. The second one in an as-is various condition. In terms of the whole situation, what are the special situations that you've encountered or you know of that majority of the public wouldn't know about?
Yes. Well, what I always recommend, rather than that clause, to be quite honest with you, I don't highly recommend the clause. I would recommend first that you have the estate certificate in hand. Okay, which is the court order in essence. And that just gives you authority to sell the property. So you're not delaying a buyer. Really, it's prudent that the executor takes action immediately when someone passes, notifies the bank, freezes the accounts, opens an estate account, and then sells. I mean, what we've encountered many times, which is why we put without penalty to the seller, if there is a delay, okay, which is my recommendation on the sales side. I've ran into scenarios where it was delayed so many times, it was to the point of frustration with the buyer, where clause wasn't put in without deduction or interest payable to the buyer. And in those scenarios, there was a shave off the price. And a reduction is significant. Like I had one file where it was a condo. My client was waiting. He was on the buy side. And for whatever reason, the estate was taking forever to come through on the sale side. So what happened? We ended up, from my perspective on the buy side, we were able to get a $25,000 reduction in price. And that was not favorable to the seller or to the estate. So you're doing an injustice to the estate as an executor or estate trustee if you list it without the estate certificate, typically. However, you should always connect with the estate's lawyer to see at what stage in the process the estate is in. If they're just about to get the estate certificate, it's prudent then to list it because you have verification. And you know it's come back already with corrections from the court. It's past that period in which someone could challenge the will. So my recommendation is find out first what stage, as a realtor, it's prudent to find out what stage the estate's lawyer is in the process. If they just filed it, it may not be wise to list it right away. It might be wise to just wait. And I know with realtors, the season is important. The summer market, spring market is the hotter market to list and sell. But that being said, you don't want to put your client in a compromising position where they have to relist it again. They have to release the deposit to the buyer or even pay damages to the buyer. In a lot of cases, there's penalties imposed on buyers, by buyers to sellers.
So what kind of instruments get registered on title in a situation in a estate sale?
So there's a couple of instruments that lawyers use. So the first is something called a survivorship application, and that's the ideal scenario. That's where you don't need probate. And that's where it's like a typical scenario is two spouses on title. They own it 50-50 as joint tenants. Joint tenants means rights of survivorship passes automatically to the other spouse, or joint tenancy, you're with a child on title or with a friend, whoever the case may be. And they've agreed that whatever their share was, it would just pass automatically without having any estate consequence. So we register an instrument on title called a survivorship application. Okay, and then that party can just sell with you automatically. There isn't any need for an estate certificate. When an estate certificate is needed and the probate filed or estate administration process is required, is we register something called a transmission application. A transmission application is when the title goes from the deceased to the estate trustee, and then the estate trustee then sells to a third party, and that instrument is called a transfer by personal rep. So you'll see 3 registrations happen, or you'll see 2 registrations happen on title, transmission and then transfer by personal rep. So a lot of people ask me, they say, well, Sarita, is there an issue when I transfer it now from deceased to my name as estate trustee and then estate trustee to me as beneficiary? Is there, what about capital gains? I own another property. There's a concern there. Well, everything happens simultaneously. So transmission gets registered, deceased to estate trustee, and then it goes automatically on that day, estate trustee to a third-party buyer. So there isn't any consequence. You're holding it literally in your name for 30 seconds.
Right.
And then if it's just left in the name of the estate, and then you're waiting for a third-party buyer, it's not you personally that owns it, even though your name is on a registration. It's just going from deceased to the party authorized to now conduct the sale. So that is always a question I get commonly, is would that affect me? Would I have to worry that, CRA is going to come back? It's just now if the beneficiary decides to hold on to it from estate trustee and they were named in the will and it goes to their name, and then they decide to hold on to it for a period of time, which you can consult with your accountant for that period of time. Yeah. And then that's when they may have to worry if they own an additional property, and we talk about capital gains.
Perfect. So what's exception where you don't need to provide a probate or a state certificate?
Yeah, so there is an exemption, which is really nice. It's called the first dealings exemption. And that was where, so I'll tell you a little bit about Ontario. In Ontario, there's a land registry office, for those that are not aware. And in that land registry office, there was a conversion from registry to land titles. Okay, and so what used to happen was when I started out in my real estate career around in the early 2000s, we had to physically go in and file a deed and a mortgage, and it would get stamped with the land registry office, and there was a person actually there you could talk to, and then you'd meet with the lawyers there, you'd shake hands for the closing, the parties would exchange keys and deeds. That no longer exists. From the 2000s, there was a transition. It started in the 90s, but the transition actually happened in the early 2000s from paper registration to now electronic registration. So there are some homes that are still in what we call land titles conversion, and they're kind of hovering there, sitting there on title, where that party has to be, the requirement is they had a will, they were the original owner of the property. I mean, there hasn't been any transfer since. So you get these older properties where these baby boomers, as an example, generally it's that generation where they've had the property since the 1960s or 1970s, and they were the original owner. And it's still, if you check the title, it's still land titles conversion. And now it's their estate that is selling the property. We can check the title as lawyers. So
it's not in the land titles yet.
Yeah, the conversion to electronic registration, it's been moved over, but it still hasn't been converted into what we call land titles absolute.
Yeah.
Okay, so there's that conversion process, and because it is not taken place, and if we see that land titles conversion, and they were the original owner, they may have something called a first dealings exemption, and we don't require probate. Mm-hmm. For that property. So I have found several of those over the years where we were able to successfully give the value of the assets to the land registry office. There's something called a covenant to indemnify, meaning the executor will indemnify the land registry office if there's any claims later on against the estate. and that is then filed with the land registry office. We typically now are able as real estate lawyers to get what we call on-land approval. So we can get approval ahead of time from the land registry office that this property in fact qualifies for the first dealings exemption. So rather than lawyers, sometimes we're guessing, we're questioning ourselves just to make sure that we're doing everything above board. We can get that confirmation now from on-land, and on-land will say, yes, this qualifies for the first dealings exemption.
Interesting.
And then we don't need probate. We don't have to wait for that estate process, even if they died with a will.
What happens with the funds?
So the funds happen the same way it would happen in any transaction. The funds go to the estate or the estate account, or goes.
But if there's no trustee, what happens then? Do you guys hold it in trust?
We hold it in trust. Okay. Yes, exactly. So what happens there is that as long as we have a will,
okay,
but it cannot be with intestate applications without a will. So first dealings, you do not qualify if you've died without a will, sadly. Even if you've qualified for first dealings, you don't have a will. So you need to have a will. You need to have a will in order to qualify, because there has to be someone nominated as executor or estate trustee. The other type
But you don't necessarily need to have the certificate.
Correct. You do not need the certificate.
Interesting. Okay.
And condos don't qualify.
And condos don't qualify.
They do not qualify because the original owner actually is the developer.
Well, I mean, like it would be in the Land Titles Act pretty much.
Correct.
So here's what I've heard off topic, that if you're not in Land Titles Absolute, and let's say if you have a fence that was placed 5 feet into the neighbor's place, and if you can show, I don't know, if 20 years or 40 years.
Yes, prescriptive easement.
Yeah, well, how many years is that?
20 years.
20 years. That's been there, and you've had pictures or some way to prove it, that land becomes yours.
Yes, that's correct. Yeah, that's correct. There's something called a prescriptive easement.
But not anymore.
You have to, if it goes into Land Titles Absolute, that means you were barred from being able to apply for that.
Yeah.
But if you're still in Land Titles Conversion, qualified, if it's still, there's still a possibility that you as a neighbor can deposit that, right? And you can make that claim for a prescriptive easement.
That's interesting. Mm-hmm. So anything else you think we should add, or I think we covered pretty much majority of it.
We've covered it, yeah. Just to be aware, just ensure that there's an understanding to those that are listening that it is a very large duty to be an executor or estate trustee and to take on that responsibility. It's a lot of financial responsibility. And again, there may be real estate involved in which, there has to be some understanding of ensuring that process goes smoothly. So I would always recommend that you contact a lawyer that has knowledge in estates law and real estate law, especially with an estate sale.
Okay.
You shouldn't go to any lawyer for that, in the sense that it's really important to have an understanding of the tax implications and all the issues involved.
Perfect. Well, guys, you heard it here first. So, Sarita, thanks for coming. And this was very informative because as agents, we run through this situation. And I know there's a lot of buyers out there looking for I would say deals, and usually you get lower price on estate sales just because of the as-is clause. But I think this was pretty well thought out presentation by you. So guys, if you need to reach out to Sarita, we have the contact information below from SST Law. We've done a lot of transactions together and she is amazing. Also, make sure to check our last episode. We talked about PDI and the issues that you have to watch out for if you're doing PDI, which is pre-delivery inspection for condos, homes, anything brand new you're buying. And like always, we'll see you next time. Have a great day.